Good morning, everybody. Welcome to this government update on sanctions relating to Russia. I'll run through the order of the presentations and then pass to the first speaker for a political overview before we get into more detail. We have speakers and input from the Foreign, Commonwealth and Development Office, the FCDO, from the Department for International Trade, the Export Control Joint Unit, from the Department for Business, Energy and Industrial Strategy, BEIS, and for the Office for Financial Sanctions Implementation, OFSI at HM Treasury. We have around an hour and a half for the briefing. As I said, it will start with a policy update. Let me preface the briefing by saying this is mainly a policy direction update and does not constitute legal advice. We will read all of the questions and comments that you've put into the chat bar, but we won't be able to answer all of them live or afterwards, but they will be really valuable to inform policymakers of your thinking. I'd like to thank everyone who has already sent in questions on Mentimeter, and also for your existing efforts and contributions to ensuring compliance with UK sanctions. You play a really important part in making them deliver efficiently and effectively. So with that brief introduction, I'm going to hand over now to Daniel Drake, the Deputy Director of Sanctions Directorate at the Foreign, Commonwealth and Development Office.
Well, thank you very much, Ian, and let me start by repeating the thanks that you said just there to all of those on the line for the really important role that you play in ensuring effective compliance with the sanctions that we have imposed on Russia. As you will no doubt be aware, we have used sanctions in an unprecedented scale and scope as part of our overall response to Russia's unwarranted and illegal invasion of Ukraine. And if we were to require any further proof of why it's important that we continue to strengthen our sanctions response, then I think the announcements overnight of sham referenda in 4 breakaway regions of Ukraine and partial mobilization within Russia should be evidence of that, and the commitment of the Kremlin to continue escalating the conflict. I'm sure you'll be aware that the current Prime Minister, as Foreign Secretary, was very determined that the UK should be at the forefront of this sanctions response. And although we have a new Foreign Secretary, his commitment absolutely remains just as firm, and he's in New York discussing that with his international counterparts right now. So our goal and our ambition to impose the highest cost on Russia for its actions in close coordination with partners remains exactly the same. Our own response has involved sanctioning well over now 1,100 individuals and over 120 entities since the start of the invasion. We've also introduced an unprecedented range of sectoral sanctions targeting trade, transport, and other areas of Russian business. And this is part, as I say, of our overall strategy of seeking to isolate Russia and to support Ukraine as it resists Russian aggression. The measures that we have taken have immobilized over 60% of the so-called war chest, the foreign reserves that are held by Russia's central bank overseas, that overall is worth around £275 billion, and those have been put beyond the reach of the Kremlin. We've also had a significant impact on Russia's ability to restock its front line, disrupting supply chains, for example, for companies such as its major drone builders, and we've also seen further evidence of weapons manufacturers suspending activity. In terms of UK-Russia trade, we place sanctions on more than £19 billion worth of UK-Russia trade, according to the 2021 figures, and our trade is now at the lowest level since records began. I think also quite significant, if you look at the most recent ONS return, is that in June the UK imported no oil, no gas and no coal from Russia, and I think that's a clear sign of markets, if you like, sort of preempting the import prohibitions that are going to be coming in towards the end of this year. We're also seeing increasing evidence of Russia emptying its stockpiles, having to strip jetliners, for example, to secure spare parts, and car component inventories that we predict should be fully depleted within 3 to 6 months. And Russia's car industry in particular has been particularly severely affected by the sanctions that have been imposed. But in the slightly longer term, what we have also done is to close off Russia's access to various advanced technologies that will have an impact on its military capabilities and its technological advantage. So these sanctions are certainly having an impact. Russia's GDP predicted to decline by up to about 8.5% this year, and by 2026 the IMF considers its economy to be potentially to be 16% smaller versus the pre-invasion trend. I'd also highlight not just the quantitative impact, but also the qualitative impact, for example, in the high-tech sector that I mentioned earlier. And I'd like to commend the role that many international businesses have played in this effort. So around 75% of foreign companies, if you look at the work of organisations such as Yale University, have responded to sanctions, and over a quarter have fully withdrawn from Russia. And as I think I said in the last one of these events, it is important that that the private sector stays the course, if you like, with us to encourage a rapid end to this terrible conflict. So these sanctions are certainly having an impact on Russia. But as we engage with other countries around the world, we are very conscious that, of course, it is possible for the conflict itself and also indirectly some of the measures that we impose to have wider economic impacts around the world. And I want to be absolutely clear that the reason that there is economic stability caused by the conflict is because of the actions of Russia itself. Nonetheless, we and our partners are very keen to take whatever steps we need to both address the humanitarian impact of the conflict and also to mitigate against any unintended consequences. I think a good example of the former is the general license that OFSI issued a couple of months ago that my colleagues from the Treasury may wish to say more about. But I also want to be clear with everyone on this call that we have not targeted, for example, the impact of third countries to buy food and fertilizers, and our sanctions are carefully targeted to avoid certain sectors of the economy, such as, for example, pharmaceuticals, which we know can have a particular impact on ordinary Russians and on our humanitarian priorities. So where those on this call are concerned about, for example, issues to do with paying for food or fertilizer, providing insurance for shipments and so on, or providing other services related to purchase and export, there is a food security licensing ground that can be applied for, which again my colleagues may say more about. And if this license is granted, that means that payments and insurance can be issued. As always, and as Ian has said, please do seek independent legal advice if ever you are unsure, but I wanted to highlight that there are these arrangements in place precisely to mitigate against the unintended consequences and humanitarian impact of our sanctions. And I think in the wider international arena, the UK remains very committed to working with our partners to mitigate the humanitarian impact and the impact on food security of the crisis. And this is obviously a predominant theme at the UN General Assembly meetings going on this week. So we very much welcome, for example, the agreement that the UN reached with Ukraine, Russia and Turkey on a humanitarian corridor to allow the resumption of maritime grain exports from Ukraine, whilst being clear that this is solving a problem that Russia itself has created. I think I would also point out in this regard the proposal that G7 finance ministers agreed last month, which again my Treasury colleagues will say more about, on the proposal for a cap on the price of Russian oil that would be implemented through an exemption to the ban on the provision of services that the EU has already agreed, and that the UK has also been looking to introduce with our G7 partners. And that's precisely because we are looking at this on the one hand to reduce the revenue that Russia can gain from its energy exports, which have helped prop up the economy despite the wider impacts that I've set out, whilst on the other hand recognising the needs of developing countries to continue exporting, continue importing oil at a reasonable price. So that's just one example of our commitment to work very closely with our partners on going further and deeper with the sanctions that we impose on Russia. And I know for this audience that it's particularly important that we align where we can with our other key partners, given that many of you are active in several different jurisdictions. Our priority will remain the G7 group of countries, but we're also working with an increasingly wide coalition, either of countries such as Australia, New Zealand and Korea and Japan and others that have imposed sanctions, or those that want to work closely with us to prevent sanctions circumvention or backfilling. And energy is a particularly good example of that, I think, where we're working along the G7 to end our own reliance on Russian energy, but also working with the international community to open up alternative sources of energy and ensure, as far as we can, market stability. So as we look at these further areas of Russian vulnerability and continue to deepen our sanctions and make further announcements, we will, of course, continue to keep you and the private sector fully informed of developments and work with you on implementing the further measures that we roll out. But let me end by saying, first of all, that sanctions are never an end in themselves, and the UK and our international partners continue to provide significant support to Ukraine's defence of its borders through military support, through humanitarian aid, and also through the discussions we are having with the Ukrainians around support for reconstruction as and when the time comes. As the Prime Minister has made clear again very recently, the UK remains entirely steadfast in its commitment to this overall strategy. So as Ian has said, today you'll hear from a range of experts from across Whitehall. This is part of our effort to engage very actively and continually for those responsible for ensuring compliance with our sanctions. Many thanks in advance for the questions that we've already received, and we hope to get to many more of those today. And let me end by thanking you again for the role that we play, for the role that you play as we respond to this gravest of threats to Euro-Atlantic peace and security. And with that, I'll hand back to Ian. Thank you.
Thank you, Daniel. I should have said at the beginning that this event will be recorded, as was the event in March, and will be available probably within a few days on gov.uk. We will also share the most useful web links to sanctions guidance that is available, and we will send that round to the Eventbrite link that you subscribed on. So, but with that, let me hand over now for some more of the context and detail on Russia sanctions to Max. Over to you.
Thanks, Ian. And like you and Daniel have said, I'm really very pleased to be here and delighted to be speaking to this audience, huge audience. Just to introduce myself, my name is Max Petrikowski. I'm head of the measures team here in the FCDO Sanctions Directorate, so leading the sectoral measures work that we're doing in Foreign Office. And as is clear from the agenda, we have colleagues from DIT and from BEIS and Treasury presenting later in this session on the technical details of our goods trade, our energy, our services trade and financial measures. So they will talk about the technical details of the sanctions measures we've introduced in this space. But I'd like to start the presentation building on what Daniel has said by putting our sanctions programme in some context, and particularly focusing on the legislative side of things. So as Daniel said just now, the UK has really been a global leader on sectoral and trade sanctions, and we've developed and led allies in introducing some really high impact measures in line with our overarching objectives in this space. And they've had a high impact. They've had a major impact. Daniel's talked about some of the impacts that we've identified. I'll run through a few others. Over 1,000 foreign businesses have left, suspended or reduced their operations in Russia since the invasion began. This has been vitally important, hugely appreciated, and it's complementary of the work that we do as governments. Russian car production, mentioned earlier, it was actually down 90% from pre-war levels. In June this year, UK imports of goods from Russia were at their lowest level since records began in January 1997. And that included, as was mentioned, 0 UK imports of Russian fuel. Pretty extraordinary given the numbers that we saw in this space just a year ago. And finally, UK exports to Russia decreased over 90% compared with the monthly average for the year up to February 2022. So how do we achieve this? If we turn to slide 5, which is on the screen, apologies, it was primarily through a huge legislative programme, and we've added 16 pieces of secondary legislation amending the Russia regulations since the invasion. And to explain and to unpack the legislative structure somewhat, the Russia regulations 2019, they came into force fully on the 31st of December 2020 at the end of the transition period. And this regime merged 3 EU Russia related sanctions regimes. There's a partial list of those 2019 regulations in slide 6, and on slide 7 we have a list of the recent legislative instruments. On slide 8, you'll be able to find a link to the consolidated version of the Russia regulations, which is available, of course, on gov.uk. And that will demonstrate and show, if you click the consolidated latest available version, the entirety of the sanctions package that we've introduced in and under the Russia regulations. And that will demonstrate and show the regulations as they stand today. All of the sanctions legislation we've laid since the invasion also has accompanying guidance, which is also on gov.uk, and the scale of the measures that we've introduced is enormous. So it's prohibiting the export of goods used in Russia's military, its security and its industrial economy. It's prohibiting the import of products that generate Russia huge trade revenue. It prohibits the provision of professional services used by Russian oligarchs and the elites. It's banned investment into Russia. It's placed restrictions on certain internet services, shipping measures, and it's also extended certain restrictions to Belarus for their part in the illegal invasion. As I mentioned at the beginning, colleagues from other departments will discuss these measures in much more detail later in the presentation, so that they'll focus on the goods prohibition, the energy measures, and the services sanctions that we've introduced. But before they take over, which will of course be the guts of this presentation, I will just briefly talk about the other side of the FCDO sanctions work, and that is the sanctions which are focused on designations. So if you can turn to slide 10. I'll talk briefly about our work on the designations front. So on the 10th of February, the Russia regulations made a number of important changes to our designations criteria. We added, as is listed up here, obtaining a benefit from or supporting the government of Russia to the definition of involved persons. We stated that this meant carrying on businesses as a government of Russia affiliated entity, carrying on business of economic significance to the government of Russia, carrying on business in a sector of strategic significance to the government of Russia, and owning or controlling directly or indirectly, or working as a director, trustee or equivalent. So that was important in in the definition of involved persons. We also, turning to slide 11, defined government of Russia affiliated entity as a person other than an individual, which is owned or controlled directly or indirectly by the government of Russia, in which the government of Russia holds directly or indirectly a minority interest, which receives or has received financing directly or indirectly from the Russian Direct Investment Fund or the National Wealth Fund, or which otherwise obtains a financial benefit or other material benefit from the government of Russia. And furthermore, on slide 12, we defined 9 sectors of the economy as sectors of strategic significance to the government of Russia. I won't read the list out, but it includes defence, energy, extractives, and a number of others. On the other side of the designations house, we also passed, moving to slide 13, please, the Economic Crime Act on the 15th of March, and that granted new powers to respond to fast-moving events by enabling the UK to align more rapidly with designations imposed by allies, streamlining decisions on UK sanctions by simplifying statutory tests for designating individuals, and also ensuring that the government can designate groups of individuals more quickly by removing some of the constraints around designation by description. And turning to slide 14, the result of this work is really impressive and significant. In total, the UK has sanctioned over 1,100 individuals, including 123 oligarchs and family members with a global net worth of over £130 billion. We sanctioned over 120 entities, including subsidiaries owned by these entities. We've sanctioned 19 Russian banks with global assets of £940 billion or more, and in conjunction with partners, over 60% of the central bank's foreign reserves have been frozen. So, so these are the critical and key statistics and background to our designations work. And I think that even though this session is focused primarily on our trade and sectoral sanctions, it's really important to start with a bit of background on our designations work, given the extent of it in the wider Russia designations picture. So, Ian, with that, I'll hand back to you, and thanks everybody for your time this morning.
Thanks very much, Max. Excellent introduction. As Daniel said at the beginning, this is one HMG presentation. It's a cross-government effort. So with that, I think it's very important that we now have a bit of comment from the Department for International Trade. I'm going to hand over to Mark.
Thank you, Ian. Good morning, everyone. Since February 2022, the government has implemented 4 trade packages against Russia. These sanctions have targeted over 90% of goods trade based on 2021 trade flows. Trade measures have been carefully designed to constrain Russian military objectives, cutting Russia off from essential goods and technologies to undermine their objectives in Ukraine. Wider measures have targeted Russia's long-term economic and strategic objectives, cutting Russia off from critical and vulnerable goods for their key sectors, including energy. And targeting particular goods and services will further signal the UK's condemnation against Russia's war in Ukraine. Now, today, I will briefly summarise the 3 trade legislative packages introduced against Russia since the previous webinar, where those measures introduced in the immediate aftermath of Russia's invasion of Ukraine were outlined. And these measures today, these measures last time, sorry, which are on the next slide. If you could, thank you. These measures covered the export of dual-use items and a range of high-tech equipment and software critical to Russia's military industrial complex and its marine and aviation sectors. It's important to note as well that the slides we've produced here today have prioritised brevity over legal accuracy, and we'd fully recommend reading legislation, including schedules in full, to get a full sense of the picture. And as always, we would recommend businesses seek appropriate legal advice on interpretation of the legislation as well. Just also useful to note as well, we won't focus on the sanctions introduced against the non-government controlled Ukrainian territories, primarily infrastructure related and military items, as well as all imports or Belarus in this session. We've also not focused on tariffs introduced since February, as this work was led out of a different team in DIT. If I can move to the next slide, please, and I'll talk to amendment number 8. And this was our second trade package that we introduced against Russia in April. And this further restricted Russian access to critical goods and technologies for their military and economic objectives in Ukraine more widely, including quantum and oil refining goods and technology. This measure also introduced a ban on the export of luxury goods, where we applied thresholds to an array of goods to ensure this measure would target the Russian elite, signalling the UK would not continue normal trade ties with Russia until they change their course of action. We also introduced a ban on the import of Russian steel and iron. I should note as well here that, as with all measures that we've introduced, we carefully considered appropriate exemptions and licensing grounds, including those to allow for trade on the basis of national security, humanitarian assistance, as was mentioned earlier, and emergencies. We have also continued to engage industry and appropriate bodies to ensure wind-down periods for contractual arrangements are included and listened to. ECGAU from DIT are here to support specific questions on licenses. We can move to the next slide, please, the first attached to amendment number 11. We delivered our third and fourth package in July of this year. Amendment 11 continued to target goods bans, including exports that would support Russian military capability. Measures were also introduced to support wider transport measures delivered earlier in the year, where we have restricted Russian access to UK airspace and landing rights and imposed further measures to degrade Russian aviation. And flip to the next slide for number 11, please. Thank you. We also impose a measure to ban the import of revenue-generating goods, a wide range of goods that would further constrain Russia's economic capacity to pursue its invasion of Ukraine. Again, good to note here, to make sure all are aware, all good measures include a ban on ancillary services, i.e. those services such as technical assistance, financial services, funds and brokering services. And this has now become the HMG default position. Next slide, please. Amendment 14 here. This ramped up our efforts even further. Introduced in late July, we denied Russian access to more goods deemed critical to their economy and imposed export bans on key services to deny Russia access to UK expertise, again to further isolate Russia's economy and key industries that directly or indirectly support the war in Ukraine. This included bans on the export of business and management consultancy, accounting and PR. My colleagues from BEIS are here today as well to discuss service measures in more detail. Next slide, please. Just to finish off amendment number 14. This also included import bans, including cutting reliance on Russia for oil and coal, and banning the import of gold that originated in Russia. It's important to note as well that throughout each package, we've remained focused on international alignment with key partners to limit Russia's ability to backfill and circumvent sanctions. Next slide, please. Lastly, just to wrap up from myself, just to reiterate what others have already said, that our sanctions are indeed working. Russian GDP declined 4.3% year on year in July, and the Kremlin is struggling to access vital goods and supplies deemed critical to their efforts in Ukraine. We're committed to imposing further measures against Russia as necessary. It's important to note that we are, of course, conscious of the impact of our measures on the UK. We've mitigated this impact through close industry engagement, implementing necessary exemptions and licenses, wind down periods, as I mentioned earlier, and appropriate business guidance to interpret legislation. We also have the export support service on hand today and generally to support with any business inquiries and questions related to the situation in Russia and Ukraine. A colleague will be around to answer any necessary questions later on. Otherwise, with that, I'll hand back to Ian.
Thanks very much, Mark. And I can just confirm that a lot of the time I've spent working on the business engagement team with the Export Support Service, which provides that service across the whole of government, is really valuable and has received a thumbs up from all the businesses that have worked with it. I think over 90% satisfaction rating. So really do commend using the Export Support Service. We'll send around the links later in the Eventbrite link that you subscribed with. Just to remind those that joined later that there will be a recording of this event. It will be on gov.uk and available shortly. So with thanks to Simon, and who mentioned sorry, with Mark, we've mentioned Bays, we've got Simon on next. Over to you, Simon.
Thank you very much, Ian. Good morning, everyone. Thank you for joining us today. I'm Simon Squire. I head up the Services Sanctions team in the Department for Business, Energy and Industrial Strategy, Bays. I'm also joined by my colleague Daniel Lung from the same team. And I'll be talking you through the sanctions on professional business services that came into force in July in relation to accounting services, business and management consulting services, and public relations services. So these sanctions relate to the aforementioned regulations 54B and 54C, and they prohibit the provisions of those services to a persons connected with Russia. What I'll talk you through in a moment is the scope of these regulations, so what things it covers, the definitions that we've used to define what these services are, and I will also talk you through that these sanctions have a number of exceptions to the regulations, and also a number of licensing grounds, that is, grounds on which one can apply for a license in order to continue to conduct an activity and provide a service into Russia. Next slide, please. So what is the scope of these regulations? So the regulation covers the export of the supply. So what that means in practice is that it doesn't matter if you are providing the service or intending to provide the service in person, remotely, or through a subsidiary. It is all captured within this regulation if it is being provided to a person connected with Russia. And what that means effectively is individuals or businesses that are ordinarily resident, located in, domiciled or incorporated in Russia. So if it is any of that, then it is within the scope of these regulations. Next slide, please. We've sought to define what covers these regulations. We need to define exactly what these three sectors are to give businesses as much clarity as we can on that. And what we've decided to do in order to do that is to use internationally recognised classifications. So for accounting services, we have used the CPC codes. That's the WTO's Central Product Classification codes that are typically used in free trade agreements. And you can see there the CPC codes that are on your screen that are used to define accountancy services and what type of services are and are not included within that. For the business management consulting services and public relations services, we have used what's called EBOPS codes. These are the UN classification system for services trade, extended balance of payment services classification, and as you can see there again, it lists out the EBOPS code that is related to these sectors to define how we have defined business consulting services and public relations services. As mentioned, actually, sorry, next slide, please. As mentioned above by my colleagues, there are a number of exceptions to these regulations that are laid out in Part 7 of the regulations. So these are areas where the regulations would not apply for specific activities. And so this includes where it is necessary to discharge or comply with UK statutory or regulatory obligations, whether it's necessary for a diplomatic mission or consular post to Russia, or if it is there's also an exception for a wind down period, although I should note for the purposes of this exception, the wind down period has already expired, so that exception would no longer apply. However, as I'll come on to in a moment, there is a licensing ground for wind down activities, or if businesses are still in the process of winding down their activities in these services from Russia. Other exceptions include where actions have been determined to be in the interest of national security, or dealing with emergencies relating to human health, infrastructure, or the environment. Next slide, please. As also mentioned before, there are a number of licensing grounds. So this is the grounds on which someone can apply for a license in order to conduct an activity. License applications can be made on the DIT's Spire system, a link to which can be found in the within the guidance that is linked on this slide. So for these prohibitions in the regulations, there are a certain number of specific activities that DIT considers are likely to be consistent with the aims of the sanctions. So if a business feels that their proposed activities fall within one of these descriptions that are listed below here, then you can explain why you believe this to be a case in an application for a license on the aforementioned Spire system. Each application is decided on a case-by-case basis, on the basis of the application that is submitted. But you can see there a number of the activities that may be considered for a license. For example, delivering humanitarian assistance, distribution of food, medical, pharmaceutical purposes that are for the benefit of the civilian population in Russia, as well as mentioned before, activities, services relating to winding down of business operations, and also services to a person connected with Russia by a UK parent company or a subsidiary of that parent company. Thank you very much. That covers the summary of the professional business services sanctions that have been implemented to date.
Thanks very much, Simon. Next, we're going to move on to Treasury and the Office of Financial Sanctions Implementation, such an important part of the whole sanctions regime. So we have a number of speakers from here, but we're going to start with Ed.
Thanks very much, Ian, and thank you everybody for joining today. My name's Ed Henley. I work in HM Treasury, and also I'm joined by my colleague Murray, who will be speaking later on today as well. I'll be updating on the new financial measures that came into force over the summer, which impose prohibitions on making new types of investments in Russia, and thereby build on the restrictions that we previously imposed on dealing with securities and money market instruments in Regulation 16 of the Russia Sanctions SI, as well as the restrictions on loans that can be found in Regulation 17, which we touched on in the previous webinar. So the new regulations prohibit UK persons from new investment activities in Russia, as defined in paragraph 2 of Regulation 18B. So in broad terms, this prohibits both directly or indirectly acquiring any ownership interest in land or persons other than individuals connected with Russia, establishing joint ventures with persons connected with Russia, and opening representative offices in Russia. The restrictions also prevent investment services in relation to prohibited activity as defined by the regulations. And it's important to note that this prohibition applies only to acquisitions of ownership interest and is not designed to prohibit selling or disposals of existing assets. Acquisitions of ownership interest in relevant entities are also prohibited where the specific purpose of such activity is to make funds directly or indirectly available to a person connected with Russia. So in this context, in Regulation 18B, a relevant entity means a person other than an individual which has a place of business located in Russia, but is not within itself a person connected with Russia. So when considering this prohibition, it's important to note that the intended purpose of the transaction is what is relevant here. So under the terms of the regulations, if the making available of funds or economic resources occurs as a result of the transaction, but is not the specific purpose or original intention of the transaction, then that is not caught by the prohibition. It is only where the specific purpose is to make funds available to a person connected with Russia. Where there are several purposes of the transaction, and one of them is to make funds available to or for the benefit of a person connected with Russia, then this would be caught by the regulations, as the regulations would cover any purpose of the transaction, be it primary or secondary. And then again, just finally to reiterate here that there is nothing in the regulations to prohibit selling or disposing of assets, as these prohibitions specifically relate to acquisitions of ownership interest rather than disposals, and Regulation 18B does not prohibit sales of existing assets. Next slide, please. So now moving on to the exceptions to the ban on investments in relation to Russia, which can be found at Regulation 60ZZA of the Russia regulations. The main points to note in relation to Regulation 60ZZA are that these regulations are not contravened by purchasing transferable securities, where such dealing is already prohibited under Regulation 16, which already prohibits dealing in securities and money market instruments, which came into force in March. And the regulations do not prohibit dealing with relevant securities issued by persons connected with Russia or relevant securities issued by relevant entities. This includes securities that are negotiable on capital markets, and it's also the case that the exception in relation to relevant securities issued by persons connected with Russia ensures that the restrictions only apply on a forward-looking basis and do not prohibit dealing with securities on a regulated market or multilateral trading facility if such securities have been issued to that market before the regulations come into force. But also important to note that the forward-looking prohibition specifically only applies to persons connected with Russia, not to the exception in relation to relevant securities issued by relevant entities, for which the exception does not apply on a forward-looking basis only. There are also a number of licensing grounds under Regulation 18B, as listed here, under which persons may apply to OFSI for a license for specified purposes of the transactions as listed here. So on that note, I will hand over to back to Ian for the next part of the financial prohibitions. Thank you.
Thanks, Ed. I think we're going straight on to stay within this group for Murray.
Yeah, thanks, Ian, and thanks, Ed. If you could head on to the next slide. So this is to flag that there will be a measure being brought in towards the end of October is when the SI, we plan to lay the SI, and this measure, based on G7 agreement on September the 2nd, plans to prohibit the provision of services that are related to the maritime transport of Russian oil and oil products from Russia to and between the third countries. This is building on the previously announced measure to ban the import of Russian oil and petroleum products into the UK, and extends this out to services offered by UK persons to the shipment of Russian oil between third countries. So this will cover not only the shipping itself by UK ships, but also technical assistance, financial services and brokering services as defined under the SAMLA legislation. If you could head on to the next slide, please, Ian. Thanks. On September the 2nd, in that same announcement, the G7 agreed that there would be an exception to these services prohibitions that will come in across the G7 based on the sale of Russian oil at or below an agreed price cap. That will be known as the price cap exception. That exception will be delivered through a general license and underpinned by an attestation model, which persons making use of the license will be required to follow. I'll set out the attestation model in more detail on the next slides. To flag here, Detailed guidance will be published alongside the general licence to support UK businesses and persons in implementing this prohibition and making use of that exception in the event that the oil or product is bought at below the cap. And we're working closely with our counterparts across the G7 to align this measure and the model and enforcement across jurisdictions to ensure there's as much alignment as possible for UK persons trading these goods. Onto the next slide, please. So the attestation model will be a tiered one, so it will be based on the proximity of a UK person to the transaction of Russian oil itself. So the first tier is where a firm is directly transacting and buying Russian oil from an exporter. These firms will be required to share as needed documents that show that the oil was purchased at or below the price cap. That documentation may include, but not be limited to, invoices, contracts, or receipts proof of accounts payable. On the next slide, there is a second tier, which are the firms that will directly interact with tier 1. So they will not have price information themselves, but they will be able to receive price information from their counterparties. This can include financial institutions. It will also include shippers. They should, when practicable, request, retain and share as needed documents that show that Russian oil was purchased at or below the cap. When it is not practical for counterparties to share that price information for commercial reasons or other reasons, they should request customer attestations in which their counterparty provides a legal commitment that the seaborne Russian oil was not purchased and will not be purchased above the price cap. We have a third tier on the next slide. Thanks, Ian. Which covers firms that do not directly have price information. So this is focused on insurers and other parties that are, 2 steps or more removed from the transaction around the oil itself. And they also have kind of different contracting timelines. They may have annual timelines, they may have semi-annual timelines. Their role and their kind of requirement for using the exception will be that they should obtain and retain customer attestations that are provided to them, where the customer has committed not to purchasing seaborne Russian oil above the price cap. They may request those attestations based on the length of their contracts, and as insurers and many counterparties already do, require in contract that their counterparty will not be in breach of sanctions legislation, and this language would be tied to that requirement in contracts. So that's a kind of high level overview of how the attestation mechanism will work. There will also be a number of other exceptions to the prohibition and licensing grounds around humanitarian and other grounds, as Ed has previously laid out for other financial measures. We're working through that at the moment, and we'll have more information on that as we move towards laying the statutory instrument at the end of October. And I'll pass on to Mike for the next section.
Murray, thank you very much. I am Mike Green, and I'm also in His Majesty's Treasury, but in the Office of Financial Sanctions Implementation. And I'll briefly speak this morning to some of the core functions of OFSI in the Russia sanctions regime. Before I start, forgive me for the slightly boring caveat, but nothing that, I think a couple of other presenters have mentioned this, but nothing that we say in this presentation constitutes legal advice. Not least because OFSI's views aren't determinative of matters of law, and they're more sort of issued for guidance and best practice. But in terms of guidance as well, I think I'd like to point to OFSI's general guidance, which is on gov.uk/OFSI, where you can find our general guidance, which is a rough overview of financial sanctions and how they work, and some tips with regards to things like licensing and ownership and control, which we'll come on to shortly. But more specifically, this morning, Ofsted has also issued Russia-specific regime guidance, which has actually only been updated this morning. So that's, I hope, indicative of how responsive we are to questions and comments and queries from industry on how to best implement the measures in this regime. And then finally as well, we can't advise enough that you actually go and look at the Russia regulations themselves. It's the regulations that form the basis upon which we issue all of our guidance, but also where all the restrictions are outlined in their fullest detail. So do go to legislation.gov.uk to have a look at those as well. And finally, from an Ofsted perspective, do, if you're not already subscribed to the Ofsted eAlert subscription service. That is in the top right hand corner of the front page of Ofstet's website, and we use that to issue messages along things around like designations and anytime anyone has been newly designated, but also when there's any update with regards to either our guidance or any of the measures, financial sanctions that my Treasury colleagues have just spoken to briefly. On Ofstet's financial sanctions licenses competency, I wanted to briefly go over this morning some of the licensing grounds which people have mentioned when going through their presentation. With regards to financial sanctions, any of the licensing grounds which appear in the legislation, Ofsted is responsible for considering any applications that people want to make for those licenses, and where it's appropriate and where we can to issue those, which essentially act as permissions to allow activity that would otherwise be prohibited by sanctions. Forgive me if this is going over old ground. The proliferation of sanctions and sanction designations means that we're dealing with a much greater number of license applications than we hitherto have. So hopefully this is all good advice, because we're seeing some applications which are a little, shall we say, in need of attention. And so we're keen to make sure that any application is as fulsome and as accurate as possible to ensure that there's a minimal delay in processing those and getting licenses issued where we can do so. In that regard as well, we've issued a couple of blogs and some guidance on the best practice for license applications, so do go and have a look at those. And that's relevant for where we're looking to issue specific licenses. So they're the ones which must be applied for in advance of any transaction which would breach sanctions prohibitions, and they can't be issued retrospectively either, so that must be done ahead of time and in good time as well. And again, we can only do that where we've the legal grounds to do so. So do go and consult the regulations and make sure that your application reflects the detail which is contained in the regulations as well. And they also, I suppose it's worth mentioning that they act as a permission. They don't act as a direction. So they allow an action to take place, and they don't compel any individual or any private entity to undertake a specific transaction. All it is our permission to say that where that transaction would previously have breached prohibitions, that we're allowing that to go ahead. And then, as Murray and Ed also mentioned, that there are some financial measures which have licensing grounds attached to them, and some of those restrictions around, for example, the loan and credit arrangements or correspondent banking relationships do come with licensing grounds as well. So if those are transactions which you are looking to undertake and you're wondering whether a license exists for them, or you can apply for one, do go and consult the regulations and see if there are any grounds under which you would be able to apply for a license to allow those transactions to go ahead. I've put on the slide there as well some of the derogations that you can apply under for a license. I think some of the most notable ones are things around legal fees, so reasonable professional fees for legal advice and legal services, and also the reimbursement of expenses for the provision of legal services. There's 2 points to note here. I think one is that it is not prohibited to provide legal services to a designated person. What you need a license for is the payment of those services, and that's an important distinction in terms of access to justice and to legal rights. And the other one is that those things must be reasonable. And again, Ofsted has published a blog on what we would consider reasonable and reasonableness in terms of legal fees, and also why that's important for for us as we seek to execute our licensing function. So do go and have a look at the OFSI blog on that. And I suppose the other one to mention as well is the idea of extraordinary situations. Do go and have a look at the guidance on extraordinary situations derogation, because unfortunately we are ticking the box and thinking that this is an extraordinary situation and therefore you should be granted a license is seldom a very strong ground upon which to apply for one. So that's not to say that it's always the case, but we do require you to go away and thoroughly consult and understand the regulations before applying for a license. And if you're unsure about that, we advise that you take independent legal counsel ahead of making an application in order to make it as strong as possible and minimise any delay. Ian, do you want to go on to the next slide? The other thing which OFSI has done a lot of during the course of this invasion is issue a number of general licenses. And as the slide says there, it's issued on behalf of the Treasury, and it basically allows multiple parties to undertake the activity which would otherwise be prohibited by legislation, but without that need to come to us on a case-by-case specific instance to apply for those individual licenses. It's worth saying that those general licenses aren't a substitute for a specific license, and we've got no legal basis that we can issue a general license for in place of a specific license. And we also don't accept applications of general licenses because they're issued by us under the conditions where we deem appropriate and mainly are considered in response to unforeseen circumstances of the sheer quantity and the complexity of designations which we've been issuing recently. It's also worth noting, I say, that each general license will include requirements for things like prior notification of use or record keeping and reporting, and each of those requirements are stated in each of the individual general licenses. So if OFSI has published a general license which you feel is applicable for your course of business, it's your responsibility to go onto the OFSI website and consult that general license to ensure that the activities that you're undertaking actually fall within the terms of that license and that what you're doing complies with any conditions of that license also. It's also worth noting that breaching the terms of a general license is an offence, and they are punishable by the same parameters upon which any breach of financial sanctions would take place as well. So do go and have a look at the OFSI military penalty guidance for those, but the OFSI general licenses page hyperlink is on the bottom at the bottom of that slide as well. So Ian, if you go on to the next slide, I think I've just put a couple of the most notable general licenses which we currently have in force. So bank fees, for example, for any financial institutions which are on the call, you are permitted under the terms of a general license to take from any frozen account the fees which you would otherwise have routinely been able to charge a designated person who is a client of yours under that general license. So again, do go and consult the terms of that to make sure exactly what you're doing is applicable under the detail of it, but that's some of the policy impetus behind that. And as Daniel said at the start of the call, one of the things that the government is very keen on doing is encouraging and aiding businesses to withdraw services from Russia to apply that maximum pressure. And in that regard, the Treasury has brought in a couple of general licenses for things like the wind down positions, including a number of designated Russian banks. So you'll see there the wind down positions involving Rosbank, which expires at the end of this month on the 30th of September. So if you have positions that are currently open with Rosbank and have not yet started to close them, do go and consult that general license and look at the terms of that to ensure that upon its expiry date, that all of the positions and all of the business which is applicable to be closed under that general license has been done so. And again, with the same idea with companies winding down operations in Russia, that one has a little longer to run. That's the 5th of November. There's a song about that, I'm sure. But do go and have a look at the general license that expires on the 5th of November with regards to a company of yours in order to be able to wind down operations in Russia. and that as a result of which might make funds or economic resources available to a DP, because that activity is covered by this specific general license. Ian, do you want to pop onto the next slide? I think that on general licenses, one of the points which I was keen to speak to, which Daniel also mentioned at the start, is that as a result of this large and severe packing of economic sanctions, the UK's total offer of grant aid to Ukraine as a result of the war totals, I think, around about £400 million now, which includes about 220 million of humanitarian aid. But as a result of the increased number of designations, the creation of space for impartial humanitarian action has been a real priority across government. So along with other departments across Whitehall, the Treasury and Office have worked to minimise any of the unintended consequences of sanctions on the delivery of that humanitarian support, the support to those affected populations. And one of the ways in which we've done this is through the humanitarian licensing provisions. But we do recognise that given the increased number of designations, that there's an increased possibility that goes along with that part of the humanitarian supply chain may be captured by those designations, which would have meant that there had been an increasing number of licensing applications that would be needed to ensure the humanitarian assistance didn't breach those regulations. And that's the rationale upon which OFSI sought to further assist the efforts of humanitarian actors in issuing a humanitarian general license, which should hopefully allow the timely delivery of humanitarian assistance activity in relation to Ukraine. So that means that relevant persons who are seeking to undertake such humanitarian activity don't need to apply for those individual licenses from OFSI, but instead they can rely more wholesale on the permissions within this general license. I think recognising that the wide-ranging need of humanitarian assistance as a result of the conflict, the general license covers activity in relation to the conflict in Ukraine, which also includes the non-government controlled regions of the country, for example, including Crimea and other non-government controlled areas of Ukraine, such as Donetsk and the Luhansk Oblast. There are also permissions in that general license for the relevant UK financial institutions to carry out any activity to affect the delivery of humanitarian assistance, and other activities as well that support basic needs in relation to the conflict in Ukraine. And that's, again, I think, recognising the very important role that UK financial institutions have in working alongside NGOs to deliver humanitarian assistance. So any UK financial institutions on the call do also go and have a look at the terms of that general license as well. As I mentioned, there are important conditions within this license. They include, for example, permissions which only extend to an improved category of organisations, and also an important provision ensuring that any funds used for humanitarian assistance and meeting basic needs must not be funds or economic resources that are already owned or controlled or held by a designated person. And that's just to ensure that designated people can't release frozen assets without the prior permission from ourselves and obviously in the Treasury, and then prevent the terms of the license being misused. However, the general license will still permit relevant persons to interact with designated financial institutions where they are necessary to delivering humanitarian aid. And again, anyone seeking to rely on those permissions in the general license should consult it and consult a copy of it on the OFSI website before undertaking any activity. And with that, Ian, I think I shall hand back to you and look forward to the Q&A later on. Thanks.
Thanks, Mike, Ed and Murray. And Mike, well done for predicting that there are quite a lot of questions for you coming up later. But we've got a couple more speakers left, and then we'll run to questions. And we'll also start publishing the questions that have come in the chat bar, which have some of those points have been addressed, but we'll seek to address the questions you've actually sent in on Mentimeter. But next step is from the Export Control Joint Unit at DIT, so handing over to Dean.
Thank you, Ian. Good afternoon, everybody. My name is Dean Gallagher, and I'm the policy lead in the Export Control Joint Unit. I work for the Department for International Trade, although the Export Control Joint Unit is, by its name, a joint unit made up of people from DIT, FCDO, and MOD. So the next few slides, I'm going to cover ECJU's role in sanctions. ECJU has a long history of working with sanctions. Our expertise is often called on to help develop sanctions measures and particularly lists of controlled items. It's important for us that trade measures can be clearly interpreted, as it will be ECJU that need to determine whether a sanctions license application is firstly for something that is actually controlled, and secondly, whether or not it can be licensed. Next slide, please. So DIT Export Control Joint Unit are the competent authority for export controls and also for trade sanctions licenses. Although our expertise is in export control measures, we will take advice from relevant teams responsible for the sanction policy area. For example, for energy related sanctions measures, we would take advice from BEIS. You've heard numerous speakers talking about licensing grounds, and we can only issue a license where there's a particular ground that allows us to do so. But just because there is a licensing ground that allows us to issue a license, it doesn't necessarily mean that a license could be issued. Next slide, please. So there are different types of license here. All of these license applications, all of these types of licenses will be considered against the licensing criteria and the sanctions regime by the statutory grounds, and also where appropriate, they be assessed against the strategic export licensing criteria. This is primarily for items which are covered by export control measures, and this would include military items, dual use items. It would include equipment for torture and civilian firearms. When we assess against these licenses against these different criteria, if, for example, a license breaches some of the strategic export licensing criteria without us even having considered the sanctions measures, the license would not be issued. These four types of licenses, I mean, the general trade licenses, cover activities such as financial services, brokering. They're not issued to an individual entity, but would be published for any relevant person who can meet the terms and conditions to use following registration. And registration to use these licenses would be made through our digital platform Spire. Open general licenses tend to cover actual movements of goods, but could also cover trade control activities, and again they're published for any relevant person who can meet the terms and conditions to use once you've registered. Standard individual license applications, they are applied for by a specific applicant to cover the proposed activities. They're normally valid for 2 years and are limited to a specific quantity or value of goods or services to a specific end user. They will expire either when the license is exhausted or when it reaches the expiry date, whichever happens first. Open individual licenses are a more flexible and tailored license that are applied for by a specific applicant to cover a broader range of proposed activities. They're not limited by specific quantity, value or services, nor are they limited to a single specific end user. But because of the wider tailored scope, they're not an easy nor a quick option for exporters. They're used more for exporters of controlled items rather than exporters of sanctioned items. And just to flag that the use of general trade licenses require records to be kept, and this comes from regulations in the Russian sanctions regulations, Regulation 76, which allows under Regulation 77 a person authorised by the Secretary of State to inspect these records. And this is primarily for us to ensure that the licences are being used correctly and only for the activities that the licences cover. Next slide, please. So I touched on it earlier, but sanctions on a country can include measures that are covered by strategic export controls, and the Russia sanctions is a good example of this, as it covers military items, dual-use items, some items subject to national control, civilian firearms. Also includes equipment which are covered by our torture regulations, and there are extensions of these export control measures which have been introduced. These extensions, I guess, if you wanted to try and describe them, they're under the critical industries list, and they are what export controls may have looked like many years ago. So they cover similar items to those controlled by export controls, but at a lower level of technical capability. And again, licenses for such goods will be assessed against sanctions regulations and the export control regulations. As I said earlier, we'd be unlikely to grant a license under a sanctions regulation if the same activity would be refused under export controls. And I shall hand you back to Ian. Thank you.
Thank you very much, Dean. Coming towards the end of the slides, just give credit to slide master Andrew, who's actually going to lead on the next slide on humanitarian assistance.
Thanks, Ian. So I think humanitarian has been touched on quite a lot throughout the session already today. Mike covered it in detail with the humanitarian general license. I think the licenses are in place. If you're unsure, then seek guidance from seek out the OFSI guidance on the general license. And licensing authorities stand ready to process licenses at pace. I think the key message is that sanctions as they are designed are not designed to get in the way of humanitarian activity. That's not our ambition, our aim of what we're trying to do here. But if you do need further information, the information is available online. We'll circulate those links after, so you can read through that at your leisure. But Mike has already covered it in significant detail, so I won't cover any further than that. Thank you, Ian.
Thanks very much, Andrew. So I think we've come to the end of the presentations, thanks to all the presenters. We're going to leave this slide up while we go through the questions. And we've also received questions that have come in during the session. I'm going to ask colleagues who can see those to publish them where they are responsible for them and able to answer. But let's start with the questions that we've received in advance. A couple of easy ones to start with, as it were. So Flavio, are you with us?
Yes, I'm here. Thanks.
Excellent. Thanks, Flavio. So let me start with two of the questions, bring them together. So can you clarify what support is given to businesses if we cannot receive payment from Russian clients for materials delivered and supplied before the war began? And the second one is there any financial support for businesses who have purchased materials for a Russian client pre-war, but now, due to sanctions, they cannot be supplied and the client will not pay?
Thank you, Ian. So at the moment, HMG has not yet announced any specific financial support for companies directly impacted by the Russian invasion. In these two questions cover payments, and I can see two options here. So either it's a problem that has to do with the contractual relationship between buyer and supplier. And so if that is the case, say the supplier doesn't want to pay, then what we would recommend is to seek independent legal advice, because it can be quite tricky, and it's very dependent on the specifics of the situation. Or the other option is that maybe the Russian counterpart is willing to pay but cannot. And if that's the case, because of the financial sanctions, what we would recommend is to speak with your bank, because they might know, might guide you, might say whether a license is needed to allow the transaction. So that's how we would reply.
Thank you very much. So the next two questions are for Bays. Let's just check if we've got Daniel with us.
Hi, Ian. Yeah, I'm on the line, thanks.
Fabulous. Let me read out the longer questions, so I'll just take them one at a time. So let's start with the first one on management consulting services. They're prohibited to provide Russians living in Russia with those services. Can you be more explicit as to what these services are, i.e. global immigration advice? Is that not allowed?
Thanks, Ian. So I think we would say you should sort of seek independent legal advice on the specific activities that you're carrying out. Regulation 54B sets out the definition for business and management consulting services, and the definition is based on the extended balance of payment services classification, the EBOPS code, and includes advisory, guidance and operational assistance services that are provided for business policy and strategy, and also the overall planning, structuring and control of an organization. The definition also says that this includes management, auditing, market management, human resources, production management and project management consulting. But I think you will need to review whether the specific services that you're carrying out fall under the definition, and whether such services are being provided to a person connected with Russia. And as mentioned, if in doubt, you should seek independent legal advice. Thanks.
Thanks very much, Daniel. So for the second question, why is there no exception for UK parent entities providing services to Russian subsidiaries, like in the US and EU rules? Will you grant standing licenses or only narrow one-off licenses?
So on this one, that we are acting with international allies to gradually ratchet up economic pressure on Russia, but we recognise that in some cases, intracorporate activities may be consistent with the aims of the sanctions, which is why the Secretary of State can grant licenses in appropriate cases. The statutory guidance includes an example of this: services to a person connected with Russia by a UK parent company or UK subsidiary of that parent company, as an example of where a license may be granted. As mentioned in the presentation, each license application will be considered on a case-by-case basis to determine whether granting a license will be consistent with the aims of the sanctions. Thanks.
Thanks very much. We've got one question that I'll just pick up, that is, and then I'll come to Treasury and Office colleagues. So this question is, if we can confirm if an individual who is registered for a British national overseas BNO status will be required to comply with UK sanctions. And the context of this one is Hong Kong residents who do not have British passports. And the answer is essentially yes. So from the SAMLA regulations 21, for this purpose, a United Kingdom national is an individual who is a British citizen, British overseas territory citizen, or a British national overseas, as we just mentioned, BNO, or a British overseas citizen. A person who, under the British Nationality Act 1981, is a British subject or a British protected person, and the meaning of the act. So the answer to that one essentially is yes. So having tipped off our colleagues from Treasury and Office, let me just start to run through some of the questions. We had the largest number. So can I just check that Mike is on the line still?
Yep, still here.
Okay, thanks, and feel free, Mike, to pass on to colleagues if it's not specifically for you. So this was on trust services. At the end of June, the UK announced a ban on the provision of trust services under its Russian sanctions regime. Has official guidance been updated with this ban? If so, where is this guidance?
Thanks, Ian. It's a good question. So the trust prohibitions haven't yet come into force, I think I'm correct in saying, but as the moment that they do, we will be issuing the relevant guidance for that. So for its location, just to hark back to what I was saying earlier about signing up to OFSI's e-alerts, do subscribe to those at gov.uk/OFSI, and when that relevant guidance is published, we'll put out through that subscription service exactly where we'll publish it.
Thanks very much. The next one is on education-related payments. So the question is on education-related payment of pharmaceutical-related payments cleared from sanctions perspective. So what about personal remittances? Sorry, that was a bit clear.
No, that's fine. I think I got the gist of it. So I probably want to start by reiterating the message that Daniel and Andrew gave throughout the course of the presentation and the webinar, that the UK government hasn't targeted sectors that are integral to humanitarian efforts, and again would urge anyone involved in humanitarian work that involves pharmaceutical work, for example, to consult the terms of the OFSI general licence so far as any financial sanctions engagement goes. In terms of personal remittances, however, I think one of the most helpful ways to think of it is to not what you're dealing with, but with who you're dealing with. So if a payment for personal remittances, for example, involves a person designated with an asset freeze, it still remains prohibited to deal with those frozen funds or economic resources that belong to a designated person who or are also owned or held by them as well. Furthermore, it's also prohibited to make funds or economic resources available to that designated person, either directly or indirectly. That's not to say that there could be grounds to license such personal remittances, however, but again, do please go and consult the regulations and OFSI's guidance, which has an entire chapter devoted to it on all of the potential license derogations that you could use.
Thanks, Mike. The next one I think may have been covered in the presentation, but it's always useful just to repeat to reinforce the message. So the question about loan and bond repayments. Can you accept loan or bond repayments, principal and or interest, from a person subject to asset freezes if that loan or bond was entered into before that person was added to the assets freeze list?
Yeah, thanks, Ian. It's a good question. The short, blunt answer is no, as they're subject to an asset freeze. But again, going back to the licensing provision, they may be able to apply for a license. And if you go and consult regulations to ascertain if there are relevant licensing grounds, there are potential for things like prior obligations that you could apply under. But do go and consult the regulations, consult our guidance, and if there are specific instances of loan or bond repayments, either the principal or the interest, which are seeking to be licensed and you're not sure, do go and seek that independent legal advice to best shape your license application before sending it to us in the Treasury.
Thanks very much. That's a slightly related question on receiving payments for a service. So if we receive payment for a service from an individual who is not designated, but from an account with a bank that is designated, should we freeze the funds?
Thanks, Ian. I think that there is a similar question which I've seen as well on a potential breaching of sanctions to make payments to an account at a sanctioned bank. What I'd strongly advise these questioners to do is go and read our enforcement notice that we served in relation to a monetary penalty we issued against a firm called TransferGo. TransferGo made an error in its assessment of whether payments to, in this case, helpful for the anecdote, the Russian National Commercial Bank They made an error in the assessment of the payments made to the RNCB as to whether or not they were subject to financial sanctions restrictions. TransferGo asserted that as relevant clients and beneficiaries were not themselves subject to financial restrictions, the payments to the accounts to the RNCB were also not breaches. However, we don't consider that's the case. Obviously, don't consider that's the case because the funds that are held in banks that are designated ultimately belong to those banks, and so therefore are also subject to sanctions. So do go onto the OFSI enforcement notice page and read the TransferGo penalty notice for more detail on that. But essentially, because the funds that are held in bank accounts of banks that are designated ultimately belong to those banks, they're also subject to sanctions. That's not to say that you can discount things for like wind down general licenses. So there will be provisions, for example, if the bank, the designated bank is subject to a wind down license. So the Rosbank general license, for example, does have permissions in it to allow a broad range of transactions to wind down that business. But in short, any bank that is subject to financial sanctions obviously considers that funds are held in those accounts that ultimately belong to the bank are also subject to the same sanctions as well.
Thanks very much. There were a couple of others. We've got a couple of minutes left only. And there's one, let me read this out. So OFSI has stated that lawyers may provide legal services to designated persons before obtaining a license to be paid, but services cannot be provided on credit. What does on credit mean?
Thanks, Ian. Yeah, it's a very good question. So just again to reiterate something that I mentioned in the presentation, which is the provision of legal services to a designated person, which is an individual or a legal person, so a firm or an entity, that is not prohibited under financial sanctions regulations. What is prohibited is the payment for those services without the requisite license. So if you're seeking to be paid for those legal services, that's where you need the specific legal services, the legal fees license. On credit is essentially paying for those services ahead of time and then cashing them in at a later date when you need the said legal services. So it would be prohibited, for example, for a designated person to seek to pay a law firm for services that they could use at a later date, again without having that specific legal fees license from OFSI. So whether it be that you want the legal services now or keeping them on credit to use them in the future, the payment for those legal services by a designated person needs to come with the requisite license from OFSI, otherwise they would breach the sanctions prohibitions.
Thank you very much. That's a comprehensive answer. I think we've got time for just one more question, and Murray picked one up in the chat, and I'll just ask Murray to deal with that.
Yeah, many thanks, Ian, and thanks to Susan for the question. So this is if a reinsurer cannot get an attestation from their reinsured insurer, as for example the reinsured at the time the reinsurance contract in SIPs, usually the 1st of January, has insufficient transparency on what its insureds will be providing to it, can the reinsurer rely on a sanctions exclusion clause, or is it at risk of being considered to have done insufficient due diligence and so should consider whether to decline the entire reinsurance treaty? It's a really good question, and we've been working through closely with insurance representative organisations both in the UK and across our counterparts in the G7 to ensure that we kind of fully reflect the complexities of the insurance and reinsurance markets in the attestation mechanism for the price cap exception. I mean, the two principles we're working to here is that the liability for any breach of sanctions, in this case the maritime services prohibition, should sit with the organisation that has been in breach and has been kind of falsifying those attestations. So in the absence of foul play from any firm further down the chain than the a firm trading with the Russian exporter directly, we would expect liability to sit first and foremost with the firm trading with the Russian exporter. In terms of insurance firms and reinsurance firms, as currently designed, there is no legal obligation for those firms to go above and beyond the due diligence that is currently undertaken with respect to claims being received. So there's not an expectation for separate due diligence to be undertaken in advance of signing contracts with counterparties. For more detail, I would point you towards OFAC's recent publication of some preliminary guidance on how the price cap exception will work. As I say, I mean, OFAC are a separate agency operating in a separate jurisdiction. However, the G7 will, as far as possible and as far as feasible, be aligning our enforcement and legal frameworks on the price cap measure. So that's a good place to go to get a sense of where we are and how we're thinking about these issues. But it's a really good question to raise, so thank you.
Thanks very much. One very, very final one, because we're almost out of time, and then I'll close out. Question is on when using outward processing export procedure of military goods to Belarus of Belarus origin, do we require import licenses to re-import the goods after warranty repair in the EU country? Answer from DIT is yes. So let me just close out by thanking all the speakers and the organisers and everyone who has joined online. We had over 3,000 signed up before today, probably more now. The recording, as I've mentioned at the top, will be on gov.uk in the next couple of days. And we will also share with you all of the links that are on this page by Eventbrite. So thank you very much for joining today, and have a good rest of the day.